Hi, Amanda.
Hi, Josh. What are we going to talk about today?
Well, the law is full of acronyms, and employment law is no exception. One of the big ones we hear thrown around in Connecticut is CHRO, and we might hear about a related acronym, EEOC. So, can you tell our viewers what's CHRO, what's EEOC, and what do they need to know about the CHRO and the EEOC if they have a discrimination or retaliation claim?
Absolutely. The CHRO is the Connecticut Commission on Human Rights and Opportunities, and the EEOC is the Equal Employment Opportunity Commission. And these are two separate entities, but they're quite related. You'll remember that we have laws in Connecticut that protect employees at work. Likewise, we have federal laws that protect employees at work. In order to have access to our court systems, you need to what's called exhaust administrative remedies first. Think about if someone was to get into a car accident as a result of someone else's negligence. The person who got hurt as a result of another person's negligence can sue that person for the damages or injuries that they sustained during that accident the very next day. There's nothing that prohibits or precludes their right or access to the courts. In employment discrimination cases, both on the state and federal level, there's a difference to that. Have to go through these administrative agencies first. For any state law claims, that's the CHRO. For any federal claims, that's the EEOC. So we get these questions a lot. Well, can I do that by myself? And is this something that I need a lawyer for? The answer is no. You don't need a lawyer to exhaust those remedies and go through the process of either the CHRO or the EEOC. However, like most other times, I strongly suggest that if you think you have a claim that you want to bring to the CHRO or the EEOC, chat with an employment lawyer about it first. The reason being is because there are some nuances in doing that. You have to file a charge of discrimination, which looks a little bit like a complaint that would come later in court. There are strategic decisions to be made. There are factual decisions that should be made about what to include or what not to include by way of allegations. So having the support of an employment lawyer before you go through that process might prove really useful and beneficial to you down the road.
I agree with that 100%, Amanda. I can't tell you the number of people who come to me and say, I filed with the CHRO, and I'm now at a phase of the process where I think I need a lawyer. And they send me what they filed, and I say, I really wish you'd come to me first. I think we could have improved this filing and could have improved your chances of success in this dispute. I want to remind people as well, they only have 300 days in most cases from the act of discrimination or retaliation to file with the CHRO or the EEOC. So talk to a lawyer and do so early. Remember, 300 days, that's an absolute deadline in most cases. If you don't file by that time, you may be out of luck. All right, we hope that's helpful for you, and we thank you so much for watching. We'll see you next time.
Take care.